United States and Michigan constitutions provide a right to trial by jury. Serving as a juror may be a personal sacrifice, but it may also be an exciting experience. Using data supplied by the Secretary of State, citizens are selected at random to receive a juror questionnaire and summons. Failure to respond to the questionnaire or report for jury duty may result in being held in contempt of court, which may involve a fine or jail term. A summoned juror should dress appropriately for court and should bring a photo ID and the jury summons to the courthouse. Upon arrival, jurors should check in with the jury clerk. There may be a delay between arrival at the courthouse and reporting to the courtroom due to last-minute efforts to settle a civil case or a last-minute plea negotiation in a criminal case. The presence of the jurors at the courthouse often encourages parties to settle their cases before the start of a trial. If a case does proceed to trial, the jurors will participate in a process called voir dire. During voir dire, jurors will be questioned by the judge, lawyers, or parties to determine if they have any personal interest, information, or connection with the case, or any bias that will influence their ability to remain neutral and render a fair decision. Jurors are either accepted by both sides or challenged by either side. A challenge for cause requires the judge to determine whether a person cannot or should not be on the jury for a legal reason. For example, if the juror is related to an involved party or has a business interest that makes him or her partial to one side. In addition, each party may excuse a limited number of jurors for no reason at all. These are called peremptory challenges. At the conclusion of voir dire, the jury will be impaneled and the oath of jurors will be administered by the court clerk. Jurors will promise to fairly decide the case. During a trial, jurors must listen to both sides, consider the evidence, and be prepared to deliver a fair and impartial verdict. It is important that jurors follow the judge's instructions. The judge is the final authority in any questions jurors have relating to their duties. Jurors must not conduct independent research about the case nor communicate about the case with anyone, including family, friends, or lawyers by any means, including electronically or through any social media. By law, jurors may not discuss the evidence in a criminal case among themselves or with anyone else until they are dismissed for deliberations. In rare cases, it may become necessary to sequester the jury. This means the jury stays together as a group, away from outside influences. Should it become necessary, it is important to understand that the court does this to ensure fairness to both sides. A civil trial is brought by the plaintiff, which may be an individual, a corporation, or a business. In a criminal trial, the prosecutor or city attorney is the plaintiff and acts on behalf of the state or municipality. The other party in either a civil or criminal trial is the defendant. The plaintiff's lawyer or prosecutor will make an opening statement in order to help jurors understand the plaintiff or the prosecutor's view of the case. The defendant may also make an opening statement. The parties may then present evidence by showing exhibits and calling witnesses to testify. Each witness may also be questioned by the other party. This is called cross-examination. The judge may permit jurors to take notes or to submit appropriate questions to ask witnesses. All notes must be kept confidential and not shared with anyone except with the other jurors during deliberations. All jurors' notes must be collected and destroyed after the trial is over. After all the evidence is presented, both parties make closing arguments. Like opening statements, closing arguments are not evidence and are only meant to help the jurors understand the case. Finally, the judge gives specific instruction to the jury regarding the law as it applies to the case. The jury will be provided with a written copy of these instructions to use during deliberation. The jury's first order of business during deliberation is to elect a foreperson who will facilitate discussion. During deliberation, jurors will share their thoughts and opinions about the testimony and evidence presented during the trial. Each juror is an equal participant and should consider it a duty to provide input by discussing the case. Jurors decide the facts based solely on witness testimony and the exhibits and materials admitted into evidence. Jurors are free to believe all, none, or part of any person's testimony. At the end of deliberations, all jurors vote. Once the verdict is reached, jurors must not tell anyone what it is until it is requested by the judge. When a verdict has been reached, a jury will be led into the courtroom, and a written verdict will be delivered to the judge. At the request of the judge, the foreperson will read the verdict. Jurors may be polled and asked to indicate agreement or disagreement with this verdict. After giving the verdict, jurors will be dismissed by the judge and will be free to go about their normal affairs. Jury service is a high civic obligation and responsibility. Our jury system depends on citizens like you, fair, impartial, and just.